Mabuhay!
We are the third-year tourism management students from the University of the East.
And we're here to give you an information and knowledge about the topic that we already tackled during our prelim period. So stay tuned and listen to our discussion. Once again,
Mabuhay!
What is political law? Political law or political activity law is an established legal practice area encompassing the intersection of politics and law. Political law comprises election law, voting rights law, campaign finance law, laws governing lobbying and lobbyists, open government laws, legislative and executive branch ethics codes, legislative procedure, administrative procedure, constitutional law, and legislative and regulatory drafting. Political laws are applied primarily to government officials, candidates, advocacy groups, lobbyists, businesses, non-profit organizations, and trade unions. Political law is that branch of public law which deals with the organization and operations of the government organs of the state and defines the relations of the state with the inhabitants of its territory.
now let's talk about the importance of political law. It is significant because political law promotes society's well-being and the common goods. According to the Article 14 of the Code of Commerce, partakes more of the nature of the administrative law because it regulates the conduct of certain public officers and employees with respect to engaging in business. Hence, political is essence. Example of it is pay to play. For instance, in the context of municipal securities dealers, rule formulated by the Municipal Securities Rulemaking Board of effectively prohibited certain individuals from contributing to the political funds of officials of issuers.
Let's now define the word constitution. A constitution is a system of fundamental laws for the governance and administration of a nation. It is supreme, imperious, absolute, and unalterable except by the authority from which it emanates. It has been defined as the fundamental and paramount law of the nation. It prescribes the permanent framework of a system of government assigned to the different departments, their respective powers and duties, and establishes certain fixed principles on which government is founded.
Do you know about the three branches of the government? Now, let's talk about it. The Philippines is a republic with a presidential form of government wherein power is equally divided among its three branches. It is the executive, legislative, and judicial. The legislative branch is authorized to make laws, alter, and repeal them through the power vested in the Philippine Congress. This institution is divided into the Senate and the House of Representatives. The executive branch is composed of the President and the Vice President who are elected by direct popular vote and serve a term of 6 years. The Constitution grants the President authority to appoint his cabinet. These departments form a large portion of the country's bureaucracy. The judicial branch holds the power to settle controversies involving rights that are legally demandable and enforceable. This branch determines whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part and instrumentality of the government. It is made up of a Supreme Court and lower courts.
Now, the question is, how was the Department of Tourism made? Started as a private initiative to promote Philippines as a major travel destination, the Philippine Tourist and Travel Association was organized in 1950. In 1956, the Board of Travel and Tourist Industry was created by Congress as stipulated in the Integrated Reorganization Plan in 1972, sanctioned as a law under Presidential Decree No. 2. As amended, the Department of Trade and Tourism was established, reorganizing the then Department of Commerce and Industry. A Philippine Tourism Commission was created under the Unified Trade and Tourism Department to oversee the growth of the tourism industry as a source of economic benefit for the country. In 1973, President Ferdinand Marcos created a new cabinet-level Department of Tourism or DOT by splitting the Department of Trade and Tourism into two separate departments. Included in the new Department of Tourism, the Philippine Tourism Authority or the PTA and the Philippine Convention Bureau PCB were created. The Department of Tourism then renamed Ministry of Tourism as a result of the shift in the form of government pursuant in the enforcement of the 1973 Constitution.
Administrative bodies related to tourism are also known as DOT Achat Agency. The Tourism Promotions Board shall formulate and implement an integrated domestic and international promotions and marketing program for the department. The TIEZA, it shall supervise and regulate the cultural, economic, and environmentally sustainable development of TES towards the primary objective of encouraging investment therein. It shall ensure strict compliance of the TES operator with the approved development plan. Intramuros Administration is responsible for the orderly restoration and development of Intramuros as a monument to the Hispanic period in Philippine history. It ensures that the general appearance of Intramuros conforms to the Philippine-Spanish architecture of the 16th to 19th century. The fourth one is the National Parks Development Committee. Upgrade and maintain assigned parks including in facilities, park grounds and landscape teams, building and structures. And the fifth one is the DFPC. Shall be a body corporate to operate the duty and tax-free merchandising system in the Philippines to augment the service facilities for tourists and to generate foreign exchange and revenue for the government as established by the department under Executive Order Number 46. And the sixth one is the Nayo Filipino Foundation to construct, improve, enlarge, or equip or to cause the building, improvement, enlarging, or equipping of the building's libraries, laboratories, workshops, or other educational accessories required for scientific research to establish, maintain, or aid others to establish or maintain institution doing research of all kinds in the fields of social science and humanities. And the next one is the PRA, mandated to develop and promote the Philippines as retirement, having as a means of accelerating the social and economic development of the country, strengthening its foreign exchange position, at the same time providing for their best quality of life to the targeted retires is a most attractive package. The next one is the Philippine Commission on Sports Scuba Diving. The PCSSD manage many of the country's recompression chambers and carries out routine spot checking on breathing air quality from the compressor of its members. And lastly is the PEZA 7916, also known as the Special Economic Zone Act of 1995, enabled the private sector to participate in the development and the management of economic zones. The Act also expanded incentives to the firms engaging in non-export activities such as commercial trade, services, utilities, and facilities, and real estate.
Organization made by the President Decree. Presidential decrees were an innovation made by President Ferdinand E. Marcos Sr. With the proclamation of martial law, they serve to allocate unto the ship executive lawmaking powers of Congress. Only President Marcos issued presidential decrees in the freedom of the Constitution of 1986. President Corazon C. Aquino recognized the validity of existing presidential decrees unless otherwise repealed. Presidential Decree Number 2035, signed on February 20, 1986, amending Section 90 of Republic Act Number 265 as amended and for other purposes. Whereas Section 90 of Republic Act Number 265 as amended prescribes, among others, that is periods of emergency or of imminent financial panic which threaten monetary and banking stability, the central bank shall grant extraordinary advances to banking institutions. Presidential Decree Number 2036, signed on February 20, 1986, creating the Commission of Human Rights of the Philippines and defining its power and function. Whereas the United Nations Charter in its preamble expresses a reaffirmation of faith and fundamental human rights in the dignity and worth of the human person, in the equal rights of men and women and the nation, large and small. Presidential Decree Number 2034, signed on February 6, 1986, providing additional period for filing application for validation of titles to lands within Baguio Town Site, reservation pursuant to PD 1371, as amended, and for payment of validation fees prescribed thereunder. Presidential Decree Number 2033, signed on February 6, 1986, governing importation of used clothing pursuant Central Bank Circular Number 1060, dated May 22, 1985. Whereas, among the liberalized items under said circular is used clothing, the importation of which is generally prohibited under Public Act Number 4653. Presidential Decree Number 2031, signed on February 4, 1986, further amending certain provision of the National Internal Revenue Code, whereas to achieve the effect of placing the raw materials and finished products at essentially the same rate of tax on finished articles under the existing tax credit system.
Presidential Decree Number 2032, signed on February 4, 1986, declaring national policies on agricultural development and promulgating the Agricultural Incentives Act of 1986. Whereas the primacy of agricultural development and incentives necessitates urgent and immediate concern by way of implementation. Presidential Decree Number 2030, signed on February 4, 1986, providing for the orderly disposition of certain assets of government institutions. Whereas the national government, through the agency of various financial and other government institutions, has acquired or is otherwise the owner of the large number of assets in the industrial, manufacturing, and commercial sectors of the economy, which as part of the economic recovery program adopted by the national government. Presidential Decree Number 2028, signed on February 4, 1986, amended Section 106 and 2004 of the Tariff and Customs Code of the Philippines. Presidential Decree Number 2027, signed on February 4, 1986, granting tax relief to distressed copper mining companies. Whereas, the government is determined to keep the industry viable considering that it earns substantial foreign exchange for the country. Presidential Decree Number 2029, signed on February 4, 1986, defining government-owned or controlled corporations and identifying their role in national development. Whereas, it is desirable that the participation of government corporations, both collectively and individually, in the development process be clarified and rationalized, taking into consideration inter alia the significant primary role of private enterprise in the various economic sectors and therefore the importance of maintaining conditions of effective competition.
The law RA 9593, the Tourism Act of 2009, was established on May 12, 2009, as a policy that acknowledged tourism as an indispensable element of the national economy and an industry of national interest and importance. In the law, tourism is seen as an industry that must be harnessed to stimulate social-economic growth. It is an act declaring a national policy for tourism as an engine of investment, employment, growth, and national development, and strengthening the Department of Tourism and its attached agency to effectively and efficiently implement that policy, and appropriating funds therefore.
They are empowered to strengthen the different agency attached to it in order to more efficiently and effectively coordinate the function and resources of the government for tourism promotion and development programs, as well as eliminate overlaps of function.
What is labor law? Labor law is legislation specifying responsibility and rights in employment, particularly the responsibility of the employer and the rights of the employee. It is a protection of employees' rights that begins with fair hiring practice. By law, an employer cannot conduct a background or credit check on an applicant without their written permission. It is also illegal for an employer to discriminate against an employee because of their age, range, and religion or country of origin. It was enacted on Labor Day of 1974 by President Ferdinand Marcos in the exercise of his then extended legislative power. It prescribed the rules of hiring and termination of private employees. The condition of work include maximum work hours and overtime. Employee benefits such as holiday, 13th month pay, and retirement pay, and the guidelines and the organization and membership in labor unions as well as in collective bargaining.
The importance of labor law. Why labor law code is important? Because it's to create a fair working environment for all parties involved and to promote the welfare of workers and stability and prosperity of society as well. It is crucial for business to ensure that their employees feel safe, welcome, and supported. It also helps to protect employees and employers while ensuring that neither is subject to unfair treatment or exploitation.
What is a learner? Learners are persons hired as trainees in semi-skilled and other industrial occupations which are non-apprenticeable and which may be learned through practical training on the job in a relatively short period of time which shall not exceed 3 months. Article number 74, when learners may be hired, learners may be employed when no experienced workers are available. The employment of learners is necessary to prevent curtailment of employment opportunities, and the employment does not create unfair competition in terms of labor costs or impair lower working standards.
So we have the different types of employment. First is the regular employment. A regular employee is similar to an indispensable cog in the corporate machine. Under the law, regular employees are those hired for activities which are necessary or desirable in the usual business of the employer. Therefore, a regular employee enjoys the benefit of security of tenure as guaranteed by the Constitution. This means that the employee cannot simply be terminated other than those just and authorized causes as provided by law. Next, we have is contractual employment. An employee under the fixed employment, also known as contractual employment, is the one who is engaged to perform a job, work, or service for a predetermined date of completion or where the employment has a specific date of termination. During the term of contract, the fixed-term employee in the Philippines cannot be terminated for causes other than those just and authorized causes provided by law, and only after due process is given to them.
For the third one, seasonal employment. Seasonal workers perform work that is seasonal in nature and are employed only for the duration of one season. Labor Code Article 294, seasonal workers who are hired every working season are considered to be regular employees. The nature of the relationship with the employer is such that during off-season, they are temporarily laid off, but when their services are needed, they are reemployed. And the last one, the casual employment. Casual employment in the Philippines is defined when an employee is engaged to perform a job insignificant to the core business of the employer. The work must be a definite period made known to both parties at the time of engagement. A casual employee is one whose work is either regular, project, or seasonal. Once they have worked for at least a year, whether continuously or not, they transition into a regular employee with respect to the employed position.
The
difference between job labor and labor-only contracting. So, job contracting is an arrangement between the principal, owner, and the contractor where a principal outsources a job or work to contractor who performs this through its deployed personnel or also called contractor's worker. It is the contractor's responsibility to perform the work and the principal has no control direction over it. The people hurt are the employees of the contractor and not by the principal. Like they are the ones who provide services, while the labor-only contracting is an arrangement where the contractor or the subcontractor merely recruits, supplies, places, workers to perform a job or work for an owner or principal. The contractor only hires people. Basically, they provide manpower only. There are three classifications of power of employers. The first one is to hire. The employer can select who will be their employees based on the classifications, qualities that your company is looking for. If you hire someone, you employ them or pay them to do a particular job for you. The second one is to control. In the sense of working, especially in the payment of salary and wages, employee management is a process that helps your workers perform at their best and achieve your business goals. And the last one is to fire. Firing is the dismissal of an employee from a job. With that, there are 4 common reasons for dismissal. The first one is failure to do the job. Perhaps the most obvious reason would be an employee's failure to do their job properly. The second is the misconduct. Another common reason for dismissal is misconduct. This could be something like regularly turning up late for work or not following workplace procedures properly. The third one is the long-term sick. Long-term illness could be a just cause for dismissal, but only if it doesn't relate to a disability and only after you have attempted to make reasonable adjustments to enable the employee to continue working. And the last one is the redundancy. Dismissal can also be due to redundancy, where the employer needs to reduce their workforce. There are special rules relating to redundancy procedures.
And now, let's talk about the just causes of termination, wherein just causes are based on acts attributable to an employee's own wrongful actions or negligence, while authorized causes refer to lawful grounds for termination which do not arise from fault or negligence of the employee. It means those instances enumerated under Article 297, termination by employer of the Labor Code. They will be terminated for their work, but there should be a valid and legal offense if observing the due process of law before terminating the employee.
While the authorized causes of termination refer to installation of labor-saving devices, redundancy, retrenchment, or downsizing, closure or cessation of operation, and disease. The rules clarify that an employee may also be terminated from employment based on the reasonable and lawful grounds specified in company policies and based on grounds provided for under collective bargaining agreements. How important is this? It is important because if the company is facing a crisis, that downsizing of their workforce is the only solution to prevent the company loses.
To sum up everything, as a citizen of the Philippines, we should know and understand the laws we have here in our country.
Laws are important because they are guidelines for a state. Without laws, citizens would not know how to act and cause harm to others. Law are aimed to common good and keep society together and functioning.
The reason why knowing some laws is important is because it allows you to protect yourself against any oppression. And it also allows you to make sure that you are acting lawfully at all times.
However, by being familiar with the laws of the state you live in, you will have much better chance at protecting yourself.
Laws should protect each one of us equally. No one should be deprived of their rights.
And when we enter the corporate world, we future professionals should know how to protect and fight for our rights as employees of a company.
The purpose of the law in the corporate world is to create a fair working environment for all parties involved and to promote the welfare of workers and the stability and prosperity of society as a whole.
It is crucial for the businesses to ensure that their employees feel safe, valued, and supported.
Law is not a law if it violates the principles of eternal justice.